and harmless. But the moment you hear any of these phrases, you need to stop talking immediately and ask for a lawyer. If an officer wants to ask you just a few questions, that is your cue to stop talking and call a lawyer. These phrases are not casual conversation. They are carefully designed psychological tactics that police are trained to use to get you to incriminate yourself, waive your rights, and provide evidence that will be used against you in court. Most seniors fall for these tactics because they were raised to be polite and cooperative with authority figures. And these phrases are designed to exploit exactly that instinct. If you are not under arrest, they can still ask you anything they like without reading the warning, but you do not have to answer. Today I am going to reveal the 5 specific phrases that should trigger immediate silence. Why police use these exact words and what they are really trying to accomplish. What happens to seniors who keep talking after hearing these phrases, and most importantly, the exact legal response you must give to protect yourself. So stay with me until the end, because I will also share the one mistake that destroys your legal protection even after you correctly invoke your rights. And if you are watching right now, please hit like so this reaches other seniors who need this protection, and comment below. Have you ever felt pressured to keep talking during a police encounter? Why seniors are especially vulnerable stakes for seniors during police questioning are uniquely high. You need to understand why this matters right now. What many people do not realize is that police are allowed to lie during interrogations. Police can legally deceive you, manipulate you, and use psychological pressure tactics to get you to talk. And seniors are particularly vulnerable to these tactics for several reasons. First, many seniors have cognitive changes that affect memory, processing speed, and ability to recognize manipulation. Police interrogation methods can lead to false confessions and wrongful convictions. According to the Innocence Project of the 251 DNA exonerations the organization has handled, as of June 2024, 28% involved false confessions. When police use rapid questioning, confusing language, or time pressure, seniors may become overwhelmed and say things that are not accurate or give up their rights without fully understanding what they are doing. Second, seniors were raised in an era when police were viewed as helpers and protectors, and refusing to cooperate was considered disrespectful. This generational difference makes seniors much more likely to answer questions they should refuse, consent to searches they should decline, and trust officers who are actually gathering evidence against them. Third, many seniors are on medications, have health conditions, or experience fatigue that makes long interrogations especially difficult. Police know this and will use extended questioning sessions to wear down resistance. They can falsely say they have evidence, claim witnesses identified you, or insist your co-defendant confessed. Their goal is not to get to the truth. Their goal is to get a statement that helps build a case against you. The financial and personal consequences of falling for these tactics are devastating. You could face criminal charges, spend thousands on legal defense, lose your reputation in your community, and suffer enormous stress and anxiety, all because you did not know that when police say certain phrases, you must stop talking immediately. Phrase number 1. Just want to ask you a few questions, Shay. First phrase that should trigger immediate silence is we just want to ask you a few questions. Or can we talk to you for a minute? Police show up saying they just want to talk. No handcuffs, no Miranda rights, just a few questions. It feels casual, harmless even, but here is the truth: it is not. This phrase sounds friendly and informal, like the officer is just trying to clear something up or get basic information. But this is one of the most dangerous traps in police interrogation tactics. Here is why this phrase is so dangerous. When police say they just want to ask a few questions, they are creating the impression that this is a casual conversation not an official interrogation. This makes you let your guard down and answer questions you should refuse. You are not required to answer police questions even if you are innocent, even if you are just a witness, and even if the officers say we just want to talk. But here is what most people do not understand. Conversely, if you are not under arrest, they can still ask you anything they like without reading a warning, but you do not have to answer. If you are not under arrest, police do not have to read you your Miranda rights before questioning you. This means everything you say during these casual few questions can be used against you in court, even though you were never warned that you have the right to remain silent. Law enforcement is not obligated to read you your rights unless you are in custody and being interrogated. So during these casual talks, you may not hear those familiar Miranda warnings, but your words can still be used against you the moment an officer says they just want to ask a few questions. You should immediately respond, "I am not comfortable answering questions without an attorney present." If police want to question you, use this exact language. "I am invoking my right to remain silent. I will not answer any questions without my lawyer present." Then stop talking. Do not try to be helpful. Do not think that answering a few simple questions will clear things up. Once you start answering, those few questions turn into many questions, and before you know it, you have provided all the evidence police need to arrest or charge you. Phrase number 2, you're not under arrest. Second phrase that should trigger immediate silence is "you are not under arrest," or "you are free to go anytime." Many people think that innocent people do not need a lawyer. That is a dangerous myth. The police may already suspect you or have evidence against you. They are not talking to you just to be friendly, they are fishing for more. This phrase is designed to make you feel safe and cooperative, but it is actually a tactical manipulation. Here is how this tactic works. Police tell you that you are not under arrest to make you think you are not in any legal danger. They want you to believe that because you are not being arrested. This conversation is not serious and you do not need to worry about protecting your rights. But here is the critical truth. If you are not under arrest, they can still ask you anything they like without reading the warning, but you do not have to answer. Just because you are not under arrest does not mean you are not a suspect. Just because you are not in handcuffs does not mean the police are not building a case against you. In fact, police often prefer to question suspects before arresting them because they do not have to give Miranda warnings and suspects are more likely to talk freely. The phrase "you are not under arrest" is specifically designed to prevent you from invoking your right to remain silent and your right to an attorney. Many people mistakenly believe these rights only apply after arrest. That is false. You also have the right to consult with an attorney before and during police questioning. Once you request a lawyer, all questioning must stop until your attorney is present. Never waive this right. You have the right to remain silent and the right to an attorney whether you are under arrest or not. When an officer says you are not under arrest but wants to ask questions, the correct response is, "Am I free to leave?" If they say yes, leave immediately. If they say no or avoid answering, say, "I want to speak with an attorney," before answering any questions. Phrase number 3. If you have nothing to hide, a third phrase that should trigger immediate silence is "if you have nothing to hide, why won't you talk to us?" or "innocent people don't need lawyers." Saying "I did not do it" may sound innocent, but it puts you in a position to defend yourself prematurely. Worse, you may contradict other facts or appear evasive under pressure. That is all it takes to give police probable cause or at least enough suspicion to escalate things. This phrase is pure psychological manipulation designed to make you feel guilty for exercising your constitutional rights. Here is why this tactic is so effective on seniors. Many seniors were raised with the belief that only guilty people refuse to cooperate with police, and that innocent people should have no problem answering questions. Police exploit this belief by suggesting that if you invoke your rights, it makes you look guilty. But this is completely backwards. Anything you say, without an attorney present, even if it seems harmless, can be used against you in court. The entire purpose of the Fifth Amendment right to remain silent and the Sixth Amendment right to counsel is to protect innocent people from being pressured into incriminating themselves. These rights exist specifically because innocent people can and do say things during questioning that make them look guilty, even when they have done nothing wrong. When police say, if you have nothing to hide, they are trying to make you prove your innocence by giving up your rights. But you do not have to prove your innocence. The government has to prove your guilt, and you have no legal obligation to help them do that. Our team understands police tactics. When we step in, law enforcement knows you mean business and that you know your rights. The correct response when police use this phrase is, I am exercising my constitutional rights. I want to speak with an attorney. Do not try to explain that you are innocent. Do not try to justify why you want a lawyer. Simply state your rights and stop talking. Phrase number 4, we can do this the easy way or the hard way. Fourth phrase that should trigger immediate silence is, we can do this the easy way or the hard way, or this will go a lot easier if you cooperate. This phrase is a direct threat disguised as friendly advice. Police can claim they have evidence, witnesses, or confessions from others that do not exist. Their goal is to get you to talk. That is why having a lawyer present is so important. An attorney can shield you from these tactics and ensure the truth comes out. Here is what police are really saying with this phrase. They are implying that if you cooperate and answer questions without a lawyer, they will go easy on you. But if you invoke your rights and refuse to talk, they will make things difficult for you by arresting you, charging you with more crimes, or treating you harshly. This is intimidation, pure and simple, and it is designed to scare you into giving up your constitutional protections. Police might tell you they have evidence linking you to a crime even if no such evidence exists. They might suggest that confessing will lead to lighter penalties even though they have no authority to make such guarantees. Here is the critical truth you need to understand. Police officers have no authority to make promises about how your case will be handled. They cannot offer you deals or lighter sentences. Only prosecutors can make those decisions. So when a police officer suggests that things will go easier if you talk, they are lying. In reality, cooperating without a lawyer usually makes things worse, not better. Anything you say can be used against you, and police are trained to use your statements to build the strongest case possible. Police interrogations are structured to gather evidence, not to prove someone's innocence. The best protection is to remain silent, clearly request an attorney, and avoid trying to handle questioning alone. When police use this threatening language, the correct response is, I am invoking my right to remain silent and my right to an attorney. Then stop talking completely, no matter what threats or promises they make. Phrase number 5. Your friend already told us everything. Fifth phrase that should trigger immediate silence is, your friend already told us everything, or we already know what happened. We just need to hear your side. Officers may imply that your friends or co-conspirators have already confessed, hoping to elicit your cooperation. This is one of the most common and effective lies that police use during interrogations. Here is how this tactic works. Police tell you that another person, maybe a friend, family member, or co-worker, has already given a statement blaming you or implicating you in a crime. They say they just want to hear your version of events to be fair. This makes you panic and want to defend yourself by telling your side of the story. But here's the truth. They can falsely say they have evidence, claim witnesses identified you, or insist your co-defendant confessed. Police are legally allowed to lie to you during interrogations. They can claim someone confessed when no one did. They can say they have evidence when they have nothing. They can tell you that your story contradicts what others said, even if they never talked to anyone else. The entire purpose of this lie is to make you start talking to correct the record or defend yourself. Once you start talking, police use your own words against you, even if you are telling the truth. If you voluntarily submit to the questioning, those answers can be used against you. An officer was not under any obligation to give you a Miranda warning because you were not in custody. You were technically free to leave and stop the interrogation at any time. Even worse, if what you say contradicts what someone else said, even slightly, police will accuse you of lying and use that as additional evidence of guilt. When police say someone else already told them everything, the correct response is I am invoking my right to remain silent. I will not answer any questions without my attorney present. Do not defend yourself. Do not try to correct their version. Do not explain your side. Anything you say will be twisted and used against you. The exact words you must say to protect yourself. No, let me give you the exact legal phrases you must use. When police say any of these 5 dangerous phrases, these words have been tested in court, approved by criminal defense attorneys, and are designed to clearly invoke your constitutional rights. There's really only one word you need to remember: lawyer. If the police want to question you, just say the word lawyer. Under Miranda v. Arizona, all questioning is required to stop when the subject asks for an attorney. The first phrase you need to memorize is I am invoking my right to remain silent. The right to remain silent is a cornerstone of Miranda rights, but simply staying quiet is not enough to invoke this right. Courts have ruled that you must explicitly state your intention to remain silent. You cannot just stay silent. You must clearly state that you are invoking your Fifth Amendment right. Simply staying quiet is not enough. You should clearly state that you are invoking this right so questioning stops. If you just refuse to answer without saying these words, police can continue questioning you, and your silence can potentially be used against you in court. The second phrase you must say is I want to speak with an attorney before answering any questions. Once you invoke your right to remain silent, request an attorney. Police questioning must stop. This clearly invokes your Sixth Amendment right to counsel. Once you say this, police are legally required to stop questioning you. Once you request a lawyer, all questioning must stop until your attorney is present. The third phrase, if police continue trying to question you, is am I free to leave? This forces police to make a legal decision. If they say yes, leave immediately. If they say no, ask am I being detained, and if so, for what crime? Clearly and unequivocally say something, like I am exercising my right to remain silent, or I want to speak to a lawyer. Once you invoke this right, police are generally required to stop questioning. Here is what you must do after saying these phrases. Stop talking completely. Do not try to explain why you want a lawyer. Do not answer follow-up questions. Do not make small talk. Silence is your power. You must use it. Be firm and consistent in your request and only engage in further conversation once your attorney arrives. Or just say the word lawyer over and over if necessary. What happens after you invoke your rights? After you clearly invoke your right to remain silent and your right to an attorney, police are legally required to stop questioning you. But you need to understand what actually happens next, because it is not as simple as police walking away. Legally, yes, once you clearly invoke your right to counsel, officers must stop questioning you. But that does not mean the room becomes silent, the officers leave, or the subtle pressure disappears. Here is what police can still legally do after you invoke your rights. First, police can continue to talk around you. They cannot ask you direct questions, but they can make comments, talk to each other, or discuss the case within your hearing. Police can still talk to you. They just cannot begin questioning you. What they can do is talk about the case, talk about evidence, talk about other suspects, talk about consequences, talk about how it looks. They do this hoping you will voluntarily start talking again. If you do, they can resume questioning. Second, police can use silence as a psychological weapon. They may leave you sitting alone in an interrogation room for long periods, making you uncomfortable and anxious. Interrogation rooms are designed to break down your ability to stay quiet. Once you invoke your rights, officers know silence becomes extremely uncomfortable. Humans are not built for it, so they leave you alone or they sit quietly near you. This is a tactic designed to make you so uncomfortable that you start talking just to fill the silence. Third, police can make casual comments that sound like they are not questions. To you, that may sound like small talk. In a courtroom, it can be. Treated as an admission, it can also allow officers to begin questioning you again. For example, an officer might say, "Well, this is going to be a long night, or your family must be worried about you." If you respond to these comments, police may argue that you voluntarily re-engaged in conversation, which allows them to resume questioning. If you reintroduce the topic, you effectively canceled your request for a lawyer. Interrogation can begin again. Court rulings have confirmed this many times. The key is that you must remain completely silent after invoking your rights. Do not respond to comments. Do not try to explain yourself. Do not ask what happens next. Just stay silent until your attorney arrives. Final advice: silence is not guilt. It is protection. Let me give you the most important final advice that could save your freedom. Invoking your right to remain silent is not a sign of guilt. It is a smart legal decision. Prosecutors cannot tell a jury you asked for a lawyer, and judges know your constitutional rights exist for a reason. Innocent people need protection too. The biggest myth about invoking your rights is that it makes you look guilty. This is completely false. Your right to remain silent, your right to an attorney exists specifically to protect innocent people. The criminal justice system recognizes that innocent people can be pressured, confused, or manipulated into saying things that make them look guilty. That is why these rights are in the Constitution. Asserting your rights is not an admission of guilt. In order to have probable cause to search your vehicle, the police officer must have observed something that has led him or her to reasonably believe that a crime has been committed. Judges and juries understand this. Prosecutors cannot tell a jury that you asked for a lawyer or remain silent, because doing so violates your constitutional rights. So there is no legal downside to invoking your rights, but there is enormous downside to waiving them. If you have already started talking, can I stop and ask for a lawyer? Yes. Even if you already started answering questions, you can stop at any time and invoke your rights. Simply say, "I am now invoking my right to remain silent. I want to speak with an attorney." Police must stop questioning at that point. Remember the 5 phrases that should trigger immediate silence. We just want to ask you a few questions. You are not under arrest. If you have nothing to hide, we can do this the easy way or the hard way. Your friend already told us everything. When you hear any of these phrases, stop talking immediately and say, "I am invoking my right to remain silent. I want to speak with an attorney." Your silence, that is your power. Use it, then use us. If police have contacted you or someone you love, do not wait. The earlier we get involved, the more we can do to protect you. Your constitutional rights are powerful, but they only work if you use them. Know these 5 phrases, memorize the legal response, and protect yourself by staying silent until your attorney arrives. Your freedom depends on it.